A comprehensive study recently published in the Baylor Law Review shows Texans access our courts responsibly. The right of trial by jury was held sacred by the founders of our country and our state. It was enshrined in the 7th Amendment of the U.S. Constitution, and Article 1 of the Texas Constitution states, quote, "The right of trial by jury shall remain inviolate," adding, quote, "all courts shall be open." It doesn't get much clearer than that. In spite of this, a heavily funded, decades-long PR campaign by corporations and their lobbyists called tort reform has sought to place severe limits on legal rights and remedies, making it much harder, if not impossible, for many individuals with deserving claims to bring their legal disputes before a jury of their peers. One of the main claims of the so-called tort reformers is that our courts are clogged with frivolous or baseless lawsuits. The authors of the Baylor study went straight to those who know our courts the best, our judges. They asked our district court judges the percentage of civil suits presented to them in the last 5 years that they would characterize as, quote, frivolous. Over 86% of the judges replied 5% or less. Even with this rare of an occurrence, as the authors note, quote, many of these cases were disposed of using the existing procedural and statutory tools which predated tort reform. Texans don't bring meritless lawsuits. And in the event someone stupidly tries, we had plenty of tools available to dispose of any bad apples. Moreover, juries don't overcompensate. The authors write, quote, 85.1% of the Texas district judges presiding over civil jury cases observed not a single instance of a disproportionately high jury verdict on either actual or exemplary damages during the preceding 60 months before the survey. Over 85% said not a single instance. In 2007, the figure was 83%. As the authors note, quote, tort reform had no discernible effect on jury outcomes. By any measure, juries appear to have gotten it right all along. Furthermore, quote, an overwhelming number of trial court judges do not perceive a need for further tort reform legislation. Our juries are our smallest, most local, and least corruptible form of government. They work hard to evaluate all the evidence, weigh credibility, and arrive at the correct and just result under the law. The jury has served as a cornerstone of our civilization for over 850 years. The fact that we empower regular citizens in this manner is one of the most important ways we protect our liberty. The authors conclude, quote, if juries get it right, why are tort reform advocates, insurance carriers, and businesses so afraid of allowing disputes to be heard by a jury of their peers? Perhaps the answer is in the question. They're afraid because juries do arrive at the correct answer. The next time an insurance company or corporate lobbyist tries to get you to give up your right to trial by jury, remember these findings. Judges who see people each and every day in their courtrooms know that our courts are used responsibly to resolve disputes. You can read the Baylor Law Study in its entirety by clicking the link below. Texas Watch stands up for the rights of consumers, patients, policyholders, and the public. Please join us in the fight to protect our rights by following our page and visiting our website, texaswatch.org.